global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, good people. Welcome back to Global Happenings Today. Still talking about financial autonomy of the local government. It's still creating a lot of tensions. The governors say they are going to take out time to review the Supreme Court verdict, while the people, Nigerians, are overly excited. Even President Bola Ahmed Tinubu has spoken up about it. Some legal luminaries have taken their stance on mostly about 18 states in the federation who are running CTC, that's Caretaker Committee government in the local government, and they have given their position on what the Supreme Court verdict actually means. Though the financial autonomy of local government may not be seen as a silver bullet for starter, but don't forget that it also depends on how well citizens will exercise their civic duties in demanding that local government chairmen perform their constitutional responsibility. However, let's look at some of the reactions of some key legal luminaries, the like of Mike Ezeome, who took out time to talk about what will happen to those who are currently running a CTC chairmanship committee in their local government. Would they still have access to money? All of that is going to talk about it. And don't forget that about 18 of them, River State is inclusive, Abia, Anambra, Katsina, Zamfara, Akwa Ibom State, Cross River State, and other states are part of it. And the likes of Kano, Sokoto, Yobe, Ondo, Osun, Enugu, Kwara, Imo, Anambra, Benue. So virtually all the south or southeastern states are doing it. Now, what will happen to them right now with the latest Supreme Court judgment on financial autonomy? Let's hear what the senior advocate of Nigeria have to say in respect to that. And according to him, Mike Ezeome, he says that the Supreme Court judgment means that the Federation Account Allocation Committee will not release funds to states like River, Abia, Anambra, Katsina, Zamfara, Akwa Ibom, Cross River, and other states with Caretaker Committee local government chairman, and that which means that their funds is going to be withheld. He says the judgment of the government is clear. If you want to receive funds from the Federation account, then conduct an election. If what you have in place is a caretaker committee as local government chairman, be sure that it will not have money from the Federation account. If you want money from the Federation account, such account or such council must be democratically elected. But let's also look at what Falana have to say about the position of the law about this, and also what Ngelale, who is a media person to President Bola Ahmed Tinubu after the Supreme Court verdict, his position, or let me say the presidency position in respect to this. But first of all, what is Falana, a senior advocate of Nigeria and human rights activist, says as he expressed support for the Supreme Court decision instructing that state government to refrain from controlling federation allocation of local government. And he says this during an interview. He says a lot depends on the Nigerian people, because right now it is difficult to talk about the autonomy of the local government. The state electoral commissions are manned by appointees of the state governors, and what they have done over the years is to manipulate the local government election in a way that only the candidate of the ruling party will be declared the winner. Now, local government will be expected to fix some schools, tar some roads, and even pay some workers. So it is not that state government will no longer participate in the affairs of the local government. The state government should create state economic council and allow the local government to participate in them, just like they are participating in the federal economic council. The judgment has to be studied by the governors so that everybody will appreciate that what the Supreme Court has done is to promote public accountability at the grassroots level. Also, the president, via one of his spokesperson, made Nigerians to understand the position of the president in the wake of the verdict. And he says, by virtue of this judgment, our people, especially the poor, will be able to hold their local leaders to account for their actions and inactions. He went further to say, what is sent to local government account will be known, and services must now be provided without excuses. My administration instituted this suit because of our unwavering belief that our people must have relief, and today's judgment will ensure that it will be only those local government or local officials elected by the people that will control the resources of the people. This judgment stands as a resounding affirmation that we can use legitimacy means of redress to restructure our country and restructure our economy to make Nigeria a better place to live in and a fairer society for all of our people. That's what the president, amidst the celebration and thanksgiving by local government chairman Ibori, who had been a former governor of Delta State from 1999 to 2007, gave a different view about this. In his write-up, he says that the Supreme Court has dealt a severe setback on the principle of federalism as defined by Section 162, subsection 3 of the 1999 Constitution as amended. The section expressly provided thus that any amount standing to the credit of the Federation account shall be distributed among the federal and state government and the local government council in each state on such terms and in such manner as may be prescribed by the National Assembly. Section 6 provides further clarity on the subject matter that each state shall maintain a special account to be called State Joint Local Government Account, into which shall be paid all allocation to the local government council of the state from the federation account and from the government of the states. That the court ruling on the matter is an assault on true federalism. A federal government has no right to interfere with the administration of local government in under any guise whatsoever. There are only two tiers of government in a federal system of government. I am opposed to fiddling with the allocation to the joint local government account at the state level, but that in itself does not call for the death knell to the clear provision of Section 164 of the Constitution. The implications of the ruling are far-reaching, and the issues that readily comes to mind are: 1. Constitutional interpretation. The Supreme Court ruling appears to contradict the explicit provision of Section 162 of the 1999 Constitution as amended. This raises question about judicial interpretation and whether the court has overstepped its bound in reinterpreting clear constitutional language. Number 2, balance of power. The ruling potentially shift the balance of power between the federal government and the state. By allowing federal intervention in local government finances, it arguably centralizes more power at the federal level, contrary to the principle of federalism. Number 3, state autonomy. This decision could be seen as an erosion of state autonomy. States are meant to have significant control over their internal affairs, including the administration of local government in a federal system. 4, financial independence. The ruling may impact the financial independence of the state and local government. If the federal government can directly intervene in local government finances, it could potentially use this as a tool for political leverage. Number 5, precedent setting. This decision could set a precedent for further federal intervention in areas traditionally reserved for state governance, potentially leading to a more centralized system of government over time. The local government must be democratically elected goes without saying. Yes, I agree. That's the position of the Constitution, but withholding the allocation is not the way to go. It's wrong. In the coming days, we will begin to fully understand the implication of the Supreme Court decision. An assault on the Constitution is not the answer to fiddling with the joint LG account. If ruling is saying governors cannot temper, touch, fiddle with the joint account, that's fine, because they shouldn't be doing that in the first place. But asking the federal government to pay local government allocation to the account of the local government directly will lead to utter chaos and avoidance or avoidable friction in governance. Like the Honorable Justice Okuta JAC of blessed memory once said in describing the Supreme Court, we are not final because we are infallible, but we are infallible only because we are final. It is my sincere hope that the judgment delivered today will be reviewed at the earliest time possible, because it clearly stands against the concept of federalism in its head. That was what he had to say. A lot of people came up lambasting him and all of that. But be that as it may, I think he has a big point there, because tomorrow, this same is an interpretation or judicial interpretation we are seeing today may be used for political leverage, as he had rightly stated. That's what we'd like to leave it. Let's meet in the comment section and talk more on this. What's your position on what Ibori really have to say? Do you think that is a product of a corrupt man, being that he was, nailed on the issue of corruption some time ago? But if you look at it objectively, do you think that he is saying nothing but the truth?
Global happenings today. We call